successful pregnancy. Unfortunately, as a direct result of the current law in New York State, we have been forced to watch helplessly from the sidelines as many otherwise healthy and loving relationships slowly deteriorated and eventually broke apart. And those are just the ones that we see from the vantage point of our clinic. Just as the current law in our state has prevented the births of countless children to loving families, so too it is obvious that it has had a destructive effect on many couples for whom a medical solution would have been easily within reach. Before I close, I'd like to share with you one last thought. The practice of reproductive medicine, as has been acknowledged, has changed rapidly and dramatically over the years. Sometimes the pace of that change has surpassed our society's ability to deal with the ethical and legal challenges that this field of medicine has brought to bear. I take great pride in having faced the ethical challenges head on and in dealing with them sensitively in ways that have allowed many couples to navigate the complex treatments that have brought many thousands of children to this world. Those children, as well as the offspring that they will in turn bear, will become part of the productive citizenry of the future. I expect that some of them will go on to do great things. I consider all of them the legacy of a professional life well lived, and I have no doubt that every fertility specialist feels that same sense of gratification. But in our jobs, we can only treat one patient or one couple at a time, so there are limits to our ability to impact the world. But you and your colleagues, on the other hand, have the power to influence on a much grander scale. With the raise of a hand or the stroke of a pen, you can put an end to the needless suffering that the current law has imposed on too many people and make it possible for so many to build healthy, loving families in New York State now and far into the future. I firmly believe that all people should have the right to pursue the medical treatment that is most appropriate for them. There should be no need for anyone to leave the state in order to have a child when they can access the medical, legal, and emotional support they need right here in New York. It is imperative that when the medical process is over and a child is born, that the legal rights and status of all parties is immediately clear. The ones who intend to be the parents of the child need to be recognized as the parents. The donors and surrogates who want to help but who have no intention of being a parent also need to be certain that their rights are protected. Today, 1 out of every 65 births in the United States is a result of IVF. It has been practiced in the U.S. since 1981 with over 5 million births worldwide. New York State is blessed with outstanding physicians and fertility practices throughout the state. It's not logical that we cannot offer this variant of IVF as a family-building option to our patients. My colleagues in New York are of one voice in this. We stand ready to treat all our patients. We ask that the legislature allow us to do that. Please pass the Child Parent Security Act. Doing so will provide hope to so many in our state. Passing this law is logical, it's fair, and it's the right thing to do. Thank you.
Thank you very much. Go ahead.
I would also...
You got it.
No.
Just try it. It
Is
might
it-
be on.
Is it on then? Good. I would also like to thank you for the opportunity to speak today and also for the proposing of this very important legislation. I am a clinical health psychologist and graduated from the University of Pennsylvania in 1989. I am currently the Associate Director of the Educational Core in the Department of Obstetrics and Gynecology at Thomas Jefferson University in Philadelphia. I am a clinical associate professor in that department as well as in the Department of Psychiatry and Human Behavior. I began my work in surrogacy in 1989, a freshly minted PhD, because the IVF group in Philadelphia needed a psychologist to help them. My husband, who was a practicing attorney at the time, was slightly horrified at the thought of all of this and shared his concerns about all the bad things that could happen with me. Yet, in a career that has spanned over 25 years, none of those bad things have occurred. I've seen the challenges as with any group of people trying to communicate and work together. I learned that surrogates were superbly capable of exploring their feelings and beliefs to decide whether this was something they could do. I've had the privilege in 1990 of being in the delivery room as new parents met their son for the first time. I've also had the extraordinary privilege of navigating new territory and contributing to both the practice and ethical guidelines. When you look at the literature, much coming from my colleagues at the University of Cambridge in England, the data back up the claim from surrogates that they do very well with their surrogacy experience. In the first published study about gestational surrogates, my colleagues and I looked at the psychological testing we did with the surrogates, their partners, and the intended parents. The study showed a remarkable thing. All of our participants were unremarkable. The intended parents were just people who want a child just like any of us would. The surrogates were women with big hearts and a wonderful love of pregnancy. The compensation they received was nice, but it wasn't the main motivator to get entangled in someone else's life's dream. It was the power of making a difference. Or as many surrogates have said to me, I'll never find the cure for cancer, but I can do pregnancy and do it well. And maybe it was this child that will be the one to find the cure. A slightly heavy burden. The hundreds of surrogates I've screened are smart, insightful, generous women who are fully capable of making their own independent, informed decisions. Informing all participants have become the foundation of the surrogate evaluation for mental health professionals. Both the Practice Committee and the Ethics Committee for the American Society for Reproductive Medicine has published best practice guidelines. All mental health professionals must practice within their training and competencies and therefore use these guidelines. Surrogates and intended parents have a unique relationship, neither family, friend, nor employment. And yet, the discussion needs to explore what each person needs and wants within the context of this new type of relationship. Respect and caring are essential to make the relationship work. All stakeholders in gestational surrogacy need to be protected, ensuring no one is entering a relationship that they can't manage and through true informed consent. Intended parents need a surrogate who can care responsibly for their child. Surrogates need to fully understand the medical and psychological risks and have full choice about whom they choose to help. Surrogates anticipate what needs their children and their partners may have. Everyone gets a voice, and these voices need to be in harmony. The most frequently asked question of a surrogate is, how can you give up that baby? Surrogates will look at you puzzled and say that the baby was never theirs to keep. So imagine you are taking care of your beloved nephew. You'll take care of him, do anything necessary, throw yourself in front of a bus for him, but you won't feel parental. You won't feel maternal or paternal. There's a line that does not get crossed, and that's the surrogacy experience. People ask me about what is the psychology behind wanting to work with a gestational surrogate or wanting to be one. The answer to the first is circumstance, and the answer to the second is compassion. The issue of circumstance, which brings parents to pursue surrogacy, leads to another frequently asked question, whether intended parents would not want the child if she or he was less than perfect, given how their expectations were so inflated. I answer by talking about being what a real parent means, the hopes and dreams that begin before your child is even conceived. Having the need for your child to grow in someone else's uterus does not subvert those dreams or hopes. If anything, it makes them stronger. These children are wanted and start off life with the best foundation, hearing, you are loved and you were wanted. Thank you.
Thank you very much. More questions?
Just one, first of all, thank both of you for your testimony. I recently, up until last year, I was a state senator that represented a big chunk of Borough Park, so I'm very familiar with Maimonides Hospital. I said to Senator Hoylman, Maimonides has the distinction of delivering more babies than any hospital on the eastern seaboard. Yeah, right. And also, Maimonides is right in the middle of the Orthodox and Hasidic community where probably the desire to have children there is greater than any other community in the city of New York. So I didn't really think about how infertility and the lack of paid compensated surrogacy could affect the Orthodox and the Hasidic community. Is there a growing demand for those services? Because infertility is also a growing problem in that community.
You're asking the right person because I've written 2 books about Jewish law and fertility therapy. I can tell you that there is no objection from that community to passing this law and to doing gestational surrogacy in general. You know, in the very recent conversation that just took place, there was a question about compensating the surrogates and whether that's unethical. So I just want to point out that nobody is questioning the actual ethics of gestational surrogacy. We already know that this legislative body has ruled that it's ethical because it's legal in New York State if it's not for pay. So the question is whether it's just compensating the gestational carrier renders the procedure unethical. And I can tell you by Jewish law, that is not an issue at all. Just compensating somebody for something that otherwise would be ethical doesn't render it unethical. After all, we don't know what the gestational carriers are doing with that money. For all we know, they're using it for medical treatment for a loved one. So the very fact of gestational surrogacy is accepted in the Orthodox Jewish community, and compensation does not change that at all.
I guess it may not be a relevant question, but I'm just curious now. Does it also require an Orthodox Jewish gestational carrier?
That's a matter of controversy, as most things are in the Jewish community.
Thank you.
So, my daughter is Jewish, and we actually are splitting hairs on determining her, you know, who considers her Jewish or not, given her egg donor and given that the surrogate wasn't Jewish. Many questions to be answered. I wanted to thank both of you, and go back to you described the profile of a surrogate, I think, quite well. What about the profile of an egg donor? Do you have a sense of who these women are?
Egg donors have had the privilege or just the extent of being old. I've probably interviewed over 1,000 donors by this point, and you'd hear a similar story. You know, yes, people always say compensation, and I think compensation is a factor in it, but usually what you will hear is the donor who makes it from inquiry all the way through to actual donation will have an and. You know, I was thinking about, it's nice that there's compensation, but what really kept me doing this is, and you hear one of three stories. Either they know somebody who went through some sort of fertility need, and it touched them, and it got them thinking. The second are women who are parents themselves, and they say, my kids are the bee's knees, and everybody should have this opportunity. And the third group is sort of more the good karma, pay it forward group, who sort of say, I would want somebody there if I needed help, or by doing this brings it brings good karma back to me. And I put them in three buckets, and of course they don't exist in three buckets. So it's usually a combination, and it is exceptional that egg donors are not seen by a mental health professional. So when you look at the studies that are out there, when you talk to the mental health professionals who are in the trenches doing this kind of screening and education with donors, you hear the same story emerge over and over again.
And Dr. Grozzi, I wanted to point out, and I'm sure you're aware, that surrogacy and IVF technology is also allowing men who are HIV positive to have children for the first time through a process of sperm washing, where the HIV fluid is actually removed from the testes, from the semen.
From the semen, you can isolate the HIV out of the sperm concentrate and use that for insemination. You can use that for insemination in women. The risk of transmission is extremely rare, extremely rare.
Is that practice undertaken in New York?
Is that practice in New York? Oh yes, Columbia University has a very, very large clinic that specializes in delivering care to HIV discordant couples. There are some issues with transferring an embryo created by an HIV positive sperm donor or husband to an HIV-negative gestational carrier, that's clear. That would, under FDA guidelines, it wouldn't be impermissible to do, but the gestational carrier would have to know that sperm source was potentially infected.
And in terms of couples traveling to other countries for gestational surrogacy, do you have a sense that New Yorkers are traveling abroad?
Oh, absolutely. We
Where would they?
They're going to India. India has a very large clinic that specializes in this, and they go mainly for one reason, which is money. It's much cheaper to do in India. I suppose there are very many legal problems that occur once the surrogacy is done over there, but that's where they're going.
Mm-hmm. And certainly, if we were concerned about exploitation, I would think of some population in surrogacy, places like India where there may not be the protections for the surrogates, particularly international legal protections. We might be concerned about that.
I would agree that that is a concern in other lands. I don't agree that it is a concern in the U.S. of A.
Mm-hmm. Thank you very much.
I have a question going back to the Jewish law issue. Do Orthodox women require a blessing from the rabbi in order to go through with this procedure, or is it considered automatically, part of getting pregnant?
It's a very pro-life, if you will, community. By that I mean very focused on culturally on family building, because historically the depletion of the Jewish community over the years. So there are very, very few situations where a rabbi, if asked, would not allow IVF or surrogacy to be done. There are some controversial issues with egg donors and surrogates, as Senator Hoylman had mentioned, but in the main, it is considered to be a normative, accepted type of treatment.
So normally a rabbi would not be asked.
By the way, when people, there are Jewish communities where people ask the rabbi advice about everything, but you ask it as if they need to give some kind of blessing over the embryos, but it's not so. They may ask advice, but there are rabbis, by the way, who specialize in reproductive Jewish law. And so those are the ones that are generally asked, and as I said, it's a pretty widely accepted technique.
Thank you. Thank you both. And our final panel is our panel of advocates, and we're going to ask Risa Levine from Resolve, Nathan Schaefer from Empire State Pride Agenda, and Gabrielle Blau from Family Equality Council. And I would just mention that New York City Now could not be here, but they offered a statement which is available, and I'll just, while our panel's getting settled, read a couple of excerpts from New York City Now. Existing New York law which bans enforceable surrogacy agreements is premised upon old medical technology, when the surrogate was the genetic mother of the child. While this ban may have been appropriate at the time, a lot has changed since the law was passed in 1992. Now people are building their families through the common and widely accepted practice of gestational surrogacy, where the carrier has no genetic connection to the child. The fact that New York law has not been updated to reflect these current realities has caused serious unintended consequences which are harming women in New York. Women in New York, unlike those in many other states, must travel out of state in order to pursue a gestational surrogacy arrangement. I'm going to skip a little. Additionally, while the father of a baby carried by a gestational surrogate is the legal father upon birth, the biological mother is forced to adopt her own baby. This is blatantly discriminatory to women. It is unfair to make women go through a cumbersome and often invasive and expensive adoption to secure legal parentage to their children. The Act corrects this inequality and makes it clear that upon the birth of a baby, the intended mother, rather than the carrier, is the legal mother. And then the conclusion is that a woman should have the freedom to choose to help a family unable to have a baby without her assistance. She should also have the right to make this reproductive choice for herself and to be paid for the time and valuable humanitarian service in helping infertile couples and same-sex couples build a family. And I would say this testimony has particular relevance because in 1992, New York City Now was one of the organizations that was in favor of banning this type of surrogacy. So for them to recognize that it's a complete change and one we're very appreciative of. And with that, I will turn to our panel that is here. And Risa, do you want to begin?
Sure. Is this on? Okay. My name is Risa Levine, and I'm a New York City resident. I'm so appreciative of Assemblymember Paulin's and Senator Hoylman's activism on this issue, and as it will help so many families across New York State. This legislation, had it been enacted a few years ago, would have benefited me personally and helped me avoid enormous personal and ongoing pain. But today, I'm speaking to you on behalf of Resolve, the National Infertility Association, of which I have served on the board of directors since 2010. Resolve is a nationwide not-for-profit dedicated to improving the lives of people living with the disease of infertility. Founded in 1974, Resolve has been active in New York State for over 20 years. You've heard some of the stories of individuals who use gestational surrogates in order to become parents. I would like to put their testimony in the context of the treatment of infertility. Over 7.3 million people in the United States are diagnosed with infertility. That's 1 in 8 families, with equal numbers being attributable to male and female factor, and about a third of the cases, both parents, both partners, or unexplained, as you heard from Marissa's testimony. Most patients can be treated by non-surgical medical treatment or procedures, but a small number, less than 5%, have issues that require treatment by in vitro fertilization. Of those, only a very small percentage are unable to carry a baby to term and require either donor eggs or a gestational surrogate. For those who do, the path to reaching that understanding and diagnosis is long and painful. The acronym for the treatment, ART, Assisted Reproductive Technology, is quite fitting because it is an art, a fair amount of trial and error to identify where the problems are and what will work. As anyone suffering from infertility can attest to, the quest for a positive pregnancy test takes over one's life. Everything else pales to a lighter shade of eggshell. And yes, it's all about the eggs. Work, family, friends, and sex. Most infertiles are afraid to admit their disease. Even in 2014, it's still deemed shameful to have a damaged reproductive system, or it's the punchline of a joke or fodder for Hollywood spoofs. For many, the only people who understand are that secret sorority of women members of privately held support groups or online and anonymous group bulletin boards. For men, it's even worse. So by the time a patient is told by her physician that she probably can't sustain a pregnancy without a surrogate, or a couple is told that they need donor egg or donor sperm, they will have been through years of medical treatment involving hundreds of injections, surgeries, and untold numbers of invasive doctor's examinations, all to have experienced repeated failure of treatment and often multiple miscarriages. A woman will have missed weeks of work and may have incurred hundreds of thousands of dollars in debt because in vitro fertilization is not required to be covered by insurance in New York State. The decision to retain a third party to carry one's child is not lightly made. For many women, carrying a child is integral to the experience of becoming a mother, being the first experience of nurturing one's child. For wannabe families who have tried so hard to become parents, first having to adjust to welcoming in teams of medical professionals into what is traditionally the most private experience a couple can have, making a baby, learning that they have to give up carrying that child, is crossing into what seems like the devil's version of Never Never Land. To then learn that in order to utilize a surrogate, one has to leave his or her home, doctors, often a partner and support system, overcome legal barriers to parenthood, and incur travel and legal fees, and then miss critical parts of the surrogate's pregnancy, it's just emotional and financial abuse. By denying access to treatment to New York's most vulnerable class of patients, those who have already endured so much, we are effectively limiting use of the available technologies to those who can afford it. This is a form of discriminatory reproductive eugenics. Surrogacy has been around since Sarah first gave her handmaiden Hagar to her husband Abraham. That we are now able to transfer the intended parent's embryo to the surrogate in a 15-minute, do you want me to wait? Sorry. That we are now able to transfer the intended parent's embryo to a surrogate in a 15-minute, unmedicated, outpatient procedure is far less extreme than having your husband personally impregnate your maid. New York State has a long, proud history of being at the forefront of medical and technological advances and has some of the best and most sought-after physicians, laboratories, and clinics in the world. To hang on to such outdated and burdensome barriers to parenthood is unwarranted obstinacy. Gloria Steinem said, "The first resistance to social change is to say it's not necessary." Infertility is hard enough. Being forced to travel out of state for a gestational surrogate or jump through legal hoops to become a parent in New York is just unconscionable. Thank you for your time. Sorry for the coffee. Sorry.
We have the wrong kind of doctors in the room for this. Thank you. Thank you so much for the opportunity to speak with you today, and thank you for advancing this very important piece of legislation. My name is Gabriel Blau. My husband, Dylan, and I live in New York City, where we are raising our 6-year-old child, Elijah, who is, of course, perfect. Our adoption attorney is in the room, which adds a special note to today. In addition to being a proud father, I'm the executive director of Family Equality Council, a national organization representing 3 million gay and lesbian parents and their 6 million children in this country. There are currently about 50,000 same-sex couples living in the state of New York, approximately 8,000 of which are currently raising children. Okay. Family Equality Council was originally established over 30 years ago by gay dads like me, but at a very different time in our country. In the early 1980s, state laws either disregarded or opposed the formation of families by LGBT parents, and surrogacy was a rare and controversial method of family formation. Today, however, we live in a completely different world, one where surrogacy has become a more widely accessible and accepted form of assisted reproductive technology. Surrogacy is one of the primary ways in which LGBT people and same-sex couples create their families, and for many couples, both same-sex and different sex, who cannot otherwise bear children. The ability to work with a surrogate to build their families is the greatest possible gift. Although we applaud New York's progress in many areas that affect LGBT families, particularly regarding marriage equality, there is more work to do. Not all of our laws have maintained pace with the advancement of our medicine, our technology, or our humanity. New York's obsolete surrogacy law is just such a law. It has forced thousands of New York couples, at least those with the financial resources to afford it, to travel out of state to form their families, incurring unnecessary costs, legal uncertainties, and other hardships for themselves and their children. Family Equality Council has been privileged to work with other progressive organizations and legislators around the country in the development of modernized surrogacy laws that replace punitive measures with common sense regulation. New York needs legislation that acknowledges the reality of gestational surrogacy as an acceptable method of family formation and provides rules and safeguards for the children, their intended parents, and the amazing, generous women who help to bring a new life into the world and create a new family. We fully support the proposed Child Parent Security Act as a carefully crafted, thoughtful way to address this issue and thereby eliminate an obstacle to family formation for New York families. A second important aspect of this proposed legislation is that it remedies the unfair, expensive process that some non-traditional families must undergo to obtain the same rights and protections that other families enjoy. In many families, especially those headed by same-sex couples, children have a legal relationship with only one of their parents. The other, who is every bit as much a parent, has no legal relationship to the child. Under current New York law, these families are forced to undergo a lengthy and expensive adoption process in order to obtain a judicial decree that will provide their children with full legal protection. And as we discussed earlier, there's now concern over married couples being able to get that protection for their children. Some families do not have the resources to do so, and as a result, children in these families are exposed to legal and financial insecurities that other children do not have to face. The Child Parent Security Act gives couples raising children a streamlined way to ensure legal recognition of both of the intended parents. The process set forth in the bill is straightforward and results in a judicial decree that will provide the security and protection that all families deserve. As Family Equality Council has evolved over the years, as New York has evolved over the years, we believe now is the time for this law to evolve. We strongly support this legislation and urge its passage immediately. The Child Parent Security Act formally acknowledges the lived realities of thousands of New York families. It honors and respects those families and thereby strengthens all of our families. Thank you.
Thank you so much. I'm Nathan Schaefer, and I'm the Executive Director of the Empire State Pride Agenda. I want to say thank you so much to the Prime sponsors and to your staff. This event has been long forthcoming, and I'm really happy that we've all gathered here today. And Senator Savino, thank you so much for your participation and for being very engaged. We certainly appreciate that. I'm going to abbreviate a bit of my testimony because I think we've carried a very cohesive yet comprehensive message today with all of our comprehensive partners. So the Pride Agenda is New York's statewide LGBT civil rights and advocacy organization. For the past 20 plus years, we've had the privilege and honor of standing up for the issues of great importance to the LGBT community. We have won more than 80 separate victories on the local and state levels. Despite these victories, however, we still face many hurdles. In particular, when it comes to creating and protecting our families, we've discovered that LGBT people face particular challenges due to current New York State law. That's why we're advocating strongly for the passage of the Child Parent Security Act. Estimates show that nearly 20% of LGBT New Yorkers are raising children, and New York State is behind many others when it comes to the laws that allow us to do so. It's due time we provide clear guidelines that define the legal status of parents so that all parties, but in particular the children, are protected from the time of birth. The law dates back to a time when reproductive technologies were very different from what they are today, and to a time when LGBT citizens were far less legally recognized than we thankfully are today. We've come a long way since the 80s and 90s, and our marriages are now protected under the law in New York State and hopefully soon across the country. We should, frankly, be able to use our own doctors and lawyers to expand our families here in New York. We increasingly hear from LGBT families who had to overcome significant legal and financial hurdles to have a child in other states. You've heard of many of those today, but I want to highlight two more. We've heard from one family from Brooklyn who had to travel cross-country with a newborn who had medical vulnerabilities at birth because the gestational carrier lived in Colorado. Yet another family who lives and works in New York is having their child in Kansas, a frightening prospect with the state's recent proposed law that it would make it legal to discriminate against its LGBT residents and visitors. It's incongruent and counterintuitive. States like Kansas and Arkansas, Florida and Georgia, Iowa and Kentucky, most of which do not recognize our marriages, and some of which don't offer any anti-discrimination practices for LGBT people, have better laws on the books than New York. No less important is the message that passage of the Child Parent Security Act would send to our entire state and to the country that we're supportive of our families and guard them from legal uncertainty. New York has long been considered a progressive state that has led the charge on many civil rights fronts, including women's rights and LGBT equality. Our outdated laws prevent us from maintaining that proud title. The Pride Agenda advocates on behalf of all LGBT New Yorkers. The challenges our families face under current law will only increase with time. Therefore, we are asking the New York State Legislature to recognize that the landscape has changed drastically. When it comes to our ability to create our families using assisted pregnancies and reproductive technologies, we need laws that match medical advances and protect all parties involved. Children of LGBT parents and of all parents deserve clear legal protections so that we can create and protect our families right here at home. Thank you so much.
Thank you. Questions?
I guess I have a couple of questions. One, I just wanted to thank each and every one of you for again, traveling here and for your advocacy on this issue. The Pride Agenda has been working closely with my staff and some of Paulin's staff, so thank you in particular for that. And I know the Family Equality Council has been leading this issue for years, and which leads me to my question, Gabriel. What kind of numbers are we looking at here? Do you have a sense of nationwide the call for gestational surrogacy? Is it a nationwide movement at this point?
I don't have numbers, but I do know and have interacted with families across the country that try to access this. Now, most states they're able to in one form or another. Not all states where they're able to is it regulated or protected. And this is one of the reasons we're so in favor of this law. This not just legalizes gestational surrogacy here in New York, but actually uses a lot of the best practices that we've learned from our work around the country. We do know that it's growing, and we have a strong belief that all reasonable ways that we can create families should be accessible, legal, and regulated.
And Nathan, your description of LGBT families going to states like Arkansas and Kansas, where they have anti-marriage laws, is a little frightening. Have we seen any cases where there have been problems encountered by those same-sex couples in those states?
I've not had any anecdote of a couple being refused service at a hospital or being discriminated in any formal way like that, but I have heard from some couples who've been to places that maybe aren't as educated or progressive, and so sometimes hospital staff might be asking questions that we hope wouldn't be asked in a place like New York, where we've been able to educate the legislature and the public about the need for anti-discrimination. So I do think it varies significantly from family to family, but it's a really important point to underscore that we shouldn't be going to these places with all kinds of legal uncertainty about the creation of our family, only to possibly be subjected to discrimination in any kind of public accommodation just for being gay or lesbian.
Thank you very much. As I'm losing my voice, this has been extraordinary, and obviously we're all going to be talking about next steps, and I know you'll all be very actively involved in that, so we appreciate it. And with that, all of you have a nice day.
Thank you.
Thank you very much.
Thank you.
Thank you. Really appreciate it.